Bill Henshaw here again, Constitutional Crisis Channel, and I've been asked to address the question, is there any such thing as a bank robbery? As amazing as it may seem, the answer to that question is no, there isn't. And I'll tell you the reasons for it. First, a quick note of how amused I get every time I go to my my library where I get on the internet for 3 or 4 hours a day. I've got to walk through Safeway and across the street to Walgreens, and next to Walgreens there's a bank. And sure enough, they have every day I see one of these security officers walking around there front and back checking things and be sure nobody's going to be breaking into the bank and stealing their money, I guess. And I never laugh at him because I know it isn't his problem. But I'm saying, my gosh, given the fact that all we have are the evidences of debt, otherwise known as Federal Reserve notes, there's no value to these. There's no intrinsic value whatsoever. So therefore, even if you went into a bank and you stole every one of these notes they had, there couldn't possibly have been committed a crime. It just doesn't work that way. What have they lost? Nothing. And I'm going to bite them back with exactly what they do to us, and I mentioned it on an earlier video today. If they're going to, on the one hand, say that the IRS and the federal government can tax us out of existence because we have no right to our time and labor in the form, no right to our time in that form because all we get are Federal Reserve notes for it, and Federal Reserve notes, if you don't know, are evidences of debt. I have the Federal Reserve itself admitting that. That's you or me on the street is an IOU. If that's true, and we have no property because of that, and because these are not property, what property has Chase Bank lost when somebody goes in there and robs them? I don't get it. It's either one way or the other. Either you have rights or you don't. But the key question for me here is, where would the jurisdiction and venue for such a trial be? Whoa. Now that gets interesting, and I go back to an acquaintance that I met years ago when I was first starting out, and unfortunately I didn't have the background and knowledge to ask questions I would have asked later on. And some of you may have heard of him, and those of you who have, if you can fill me in on more information, I'll tell you more about that later. Jerome Daly, D-A-L-Y. And he came to our meetings. I was, at the time, belonged to the Constitutional Heritage Protection Society. A bunch of us kooks got together and discussed, some really crazy stuff. And Jerome was there for a couple of meetings, and at the time, I didn't know about his involvement with the case of Turner versus American Bar. I'll discuss that a little later. What I did learn was that as an attorney in Minnesota, he had actually gone into a Minnesota Justice Court and gotten the Federal Reserve declared unconstitutional. Any of you that might happen to have a hard copy of that order, I would love to see it. I don't have one. I didn't have enough sense to ask Jerome for a copy if he had one. Now, apparently it was later reversed by the Minnesota Supreme Court, and I would love to have a copy of that order if it exists. All of this might have been done off the record for all we know. But he did that. And he got in even more trouble later when one of his clients came in to his office and had gotten a hold of some ink and paper and printed up some of these. And of course he got charged with by the federal government, with what's the word for it?
Counterfeiting.
Counterfeiting, thank you. Couldn't think of it. Counterfeiting. Well, Jerome goes into the federal court with a motion to dismiss on the grounds that Federal Reserve notes are not obligations of the United States pursuant to Title 18 of the U.S. Code, which is the criminal code, for those of you who don't know. The judge threw the case out. Jerome was right. No jurisdiction and venue. What happens to him later, and I don't have full details here, but any of you that can help fill me in, I'd love to hear it. But I do know that he was charged with several fraudulent tax crimes and got convicted and was put on about 18 years probation, unheard of at the time. This is about 1970, and ordered not to talk about what he knew. That didn't stop him, because he showed up at our CHPA, as I said, out there in Contra Costa County, where I learned a lot of this stuff. So you see, with evidences of debt, there's no loss, there's no possible way for an injured party to come in there as a result of a bank robbery, quote unquote. Doesn't exist. I mean, if that's the rules they're going to use against us, then they have to apply to them, do they not? So, number one. Number two, if it was going to be a federal criminal trial, then it would have to be in a federal judicial court situated in one of the states admitted into this union. Since there aren't any of those, and for my money, there are no federal judicial courts at all, with the possible exception of the Supreme Court of the United States, which is provided for, as you know, by Article 3 of the Constitution, then anywhere you get in a legislative tribunal, what do we not have there? Judicial process. Trial by jury according to the course of the common law. The Constitution calls that a bill of attainder, and so do I. And it's to the point where if you study your history, you're going to find out with the Northwest Ordinance of 1787 that was enacted and reenacted by the first Congress, by the way, after the Constitution was ratified. It says right in there that inhabitants of territories have the right to judicial proceedings according to the course of the common law and the right to trial by jury. Inhabitants of territories. If they have those rights, how can they haul a state citizen or anyone else for that matter into a federal court and say in effect that you don't? Yeah, you might get what looks like a trial by jury, but that's not what's going on there, because they have the jury completely under their thumb. They're going to instruct them what the law is and tell them to convict you. It's a directed verdict of guilt. Now, that's one of the changes I'm trying to make. And I haven't mentioned it often, but I'm going to mention it now. I have another packet of documents, my jury instruction packet, right now close to 600 and will soon be more than that. I've never had to use it, even in my South Carolina felony case, where my good friend and cameraman here sent a digital copy to them in Columbia. I would love to have seen the looks on their faces when they saw this one. I mean, as bad as it was up to that point, 600 jury instructions. My God, you wouldn't get that for any case you can possibly think of. I mean, my God, O.J. Simpson had what, maybe 35 or 40 in that case where he shouldn't have got off. Story for another day. 35 or 40. I'm here with close to 600. And I'm telling the jury what the law is so they will know, because I know damn well the government didn't teach them either. Somebody has to do it, or I can't get a fair trial by jury, and neither can you. Bill of Attainder. That's what we should be arguing, not the damn 4th, 5th, 6th Amendments. None of that's any good. We don't need it. We've got them dead to rights in the first 6 articles of the Constitution. So that's why I say, no jurisdiction in federal courts. Now, the quote-unquote state courts, again, since we don't have any of those, that's a real big problem for them jurisdiction-wise. And if they're going to try you pursuant to a violation of a law that is under the Commerce Clause powers of Congress, that's jurisdiction a state court, even if they exist, cannot exercise. Article 3, Section 2 is quite clear on that. You can check out also Section 9 of the Judiciary Act of 1789. So you don't have state courts either. So where is the jurisdiction and venue here? Any good defense lawyer is going to have a field day with that. And it's a question I would personally like to ask people like Jack McCoy. Jurisdiction and venue, where is it? I don't see it. So yeah, we don't have, there's no such thing as a bank robbery, and really no such thing as banks, at least in the sense they would be understood at common law, which was bad enough as far as I'm concerned. But now when they're in Admiralty, can loan out evidences of debt and do it with touching a couple of buttons on their computer, and then they want you to pay them back for 30 years with the mortgage from your blood, sweat, and tears, where you have to go out and earn it. I have a real problem with that, and the Constitution does too, if we make the right arguments with the right status and in the right courts. Right now, I've got 2 out of 3 of those, and I'm getting very close to having a trifecta. When that happens, you'll be among the first to know it. Thank you.